Hey everyone, and welcome to today's video. We got 3 courtroom masterminds to look at today, each one suffering from a severe case of saying the quiet part out loud, and every single one of them ends up paying for it with their freedom. We're starting off in Indiana, where a defendant was hauled back into court after violating his bond conditions by catching a brand new charge. So let's get into it.
This is case 01D01-2601F65, State of Indiana versus Michael Mock. Mr. Mock is present in the courtroom via video teleconference from the Adams County Detention Center. His attorney, Mr. Cowan, is sitting right here in front of me. Mr. Chad Thurston is present in the courtroom for the state. He appears via WebEx. This hearing is being broadcast on the Supreme Court's website, and recording of it is prohibited. We're here after notice to the court 1.1, a notice of a violation of pretrial services. It alleges that there was a pretrial release condition number 9 that was violated that says you shall not commit, be arrested, or charged with a criminal offense during the period of pretrial release. The court takes judicial notice of case 90D01-2602 CM38 over there in Wells County, which is a pending matter that was filed in Wells County last week. And based on that, the court notes the violation of pretrial service, issued a warrant for Mr. Mock's arrest, and that's why we're here today. We have let's see here. Looks like we have a attorney conference that's scheduled for February 17th. The omnibus date in this case is March 30th. Mr. Cowan is already representing Mr. Mock. Mr. Cowan, is there anything that you'd like to put on the record here today?
Judge, my client would ask that he be released back under pretrial services. He doesn't believe that the charges in Wells County are valid. Okay. That they happened while he was arrested on February 3rd. He believes that all stemmed from a matter that happened before February 3rd. Okay. He'd like to be released back under pretrial services. And if not, then Judge, we just need to set this matter. Either way, we need to set this matter for another pretrial conference because there's some depositions he wants me to take, and then we can hopefully get a better assessment on this case.
That makes sense. The attorney conference is already on February 17th. Do you want an additional pretrial conference after that?
The February 17th. Well, if we have an attorney conference, Judge, that'd be great.
I'm sorry, an additional attorney conference?
Yeah, I'm sorry, a pretrial conference in the court.
Okay, all right, yep, we'll do that. And then with regards to the request to be released, the court notes the probable cause. I note it is probable cause, and Mr. Mock definitely has a right to defend himself against the charges in Wells County, obviously. But with regards to that issue, because it's pending, because that was a condition of pretrial release, the court's not that request.
That's 3 conditions. That's 3 conditions in one. I can't help it. I was arrested on a charge scheduled for July 2nd of last year, and it was in my own driveway. And there's common master.
I'm not going to let you do Mr. Mock as talk over me. I'm sorry. I didn't already instruct you. I didn't explain to you before that you can't have bifurcated representation. You can't speak and be represented by counsel at the same time. And so Mr. Cowan is representing you, and he's made very clear that you're contesting the issues there in Wells County and that you have defenses to them. And obviously that I'm not the Wells County judge, and so I'll let you take those up with the Wells County judge. But with regards to this pretrial release, that condition has been violated because of those new charges, and so we held without bond for the time.
That's against my constitutional rights. That's against my constitutional rights. I paid $500,000. What?
That's all we have this hearing. This hearing is concluded.
All right, you're a dick sucking bitch, ho. Hey, John, I wrote Chad Cooper Hahn.
Officers, please hold him right there. Please hold him right there. We're not done yet. So far, Mr. Mock has referred to the court as a hoe and something else. You're going to be held in contempt of court. I'm going to hold you I find that you are in contempt, and you'll be held at the Adams County Detention Center for the next 30 actual days. Okay, keep it up, Mr. Mock, and you'll be held in contempt even longer. All right? 30 actual days is your sentence. This hearing is concluded.
Well, that could not have gone much worse for him. And the crazy part is that he may actually have had a legitimate argument regarding the alleged bond violation. According to him, the new offense supposedly occurred before his bond conditions were even put in place. If that turned out to be true, there's a possibility the court could have reconsidered or even reinstated his bond at a later hearing. Instead, He chose to unload on the courtroom and earned himself a direct criminal contempt finding under Indiana law. And that's where things become a serious problem for him. Even though the contempt statute appears within civil procedure, the court still uses a language of criminal guilt when someone is found in direct contempt. In other words, he didn't just insult the court. He potentially handed prosecutors an argument that he committed a new criminal act while already out on bond rather than helping his situation. He may have accidentally made it significantly worse. Next, we head over to Colorado, a state that's usually pretty tolerant when defendants start cursing in court. But today, patience was in very short supply.
Paul LaBouche, 26 CR 9, 25 M 529, 25 CR 216. Okay, the defendant appears in custody, and this was a conflict, right?
Yes.
Okay. So, Mr. LaBouche, a couple things. Let me click over to your cases. Okay, so first off, I'll ask you, did you see and understand the video advisement of your rights before today's
Yes.
hearing?
Yes.
And in your cases, you have one new case. That would be 26 CR9. All those rights that you were advised of in that video apply to this case. You understand that?
Yes.
The charges in that case include felony menacing as a class 5 felony. As a class 5 felony, that's potentially punishable by 1 to 3 years in prison and or $1,000 to $100,000 fine. If there's extraordinary circumstances, it could be as low as 6 months or as much as 6 years in prison. It would also be followed by a 2-year period of mandatory parole. Count 2 is a charge of protection order violation as a class 1 misdemeanor. That is potentially punishable by up to 364 days in jail and or up to $1,000 fine. So on your new case, do you understand?
Yeah, but I don't know when this case is even. Who's it against? Who's the
The case is against you.
oh, and who's the victim of the fucking case?
Whoa, easy there. That mouth sounds like it was raised in a demolition derby. But believe it or not, that still wasn't the worst part, because things somehow managed to spiral even further downhill from here.
Okay, you know what, Mr. LaBouche? I'm
What?
sure you're inconvenienced, and I'm happy to answer some questions, but I am going to instruct you not to curse during this hearing. I'll treat you with respect. You need to treat the courts and those who are present with respect as well. So,
Indeed.
Mr. Fowler, the question was who it involves. Is that the name protected party that you're going to be seeking?
It is, Judge. That name protected party is very concerned about having their address out, and has asked insofar as we're able
Okay.
to keep that information private.
So, Mr. LaBouche, the person who's alleged to be the named victim is a River Williams.
River Williams.
That's the name that I've been given.
I don't know this person at all.
Okay.
At all.
Well, that's what you're charged with right now. That's the person that's going to be the name protected party. That's what I can tell you at this time. You will have a right to discovery, so you can, if you're represented by counsel, they can get your discovery, which would be the reports and other evidence against you. You can also get it by, I think, simply submitting a written request, and the DA's office will get that for you. And that will have all the facts that they are aware of. So that's the first case, 26 CR9. Additionally, in your other two cases, they have been filed as probation complaints. Go ahead and grab those. Your rights on a probation complaint are slightly different than your rights when you were originally arrested on the charge. In a probation complaint, you have a right to a hearing before a judge. You do not have a right to a jury trial. You would have the right to be represented by an attorney, and if you cannot afford an attorney, You can apply for representation by the public defender. If you're in custody, you would automatically qualify. In this case, Ms. Drinkwater, who's with the public defender's office, indicated they have a conflict. And that's why they're not here today representing you. We also currently do not have any alternate defense counsel joining this hearing. Again, as it relates to a probation complaint, you are presumed to be innocent of the allegation until proven guilty by a preponderance of the evidence. That's another difference. The allegation does not have to be proved beyond a reasonable doubt, so it's a lower standard of proof. At that hearing, you'd have the right to testify, to call your own witnesses, to present your own evidence and defenses, to cross-examine and confront witnesses against you, and to appeal any decision you believe the court made an error. So those are the modified rights you have in 25M 529 and 25 CR 216. I will tell you what's being alleged in those cases as well. They allege that you violated the following standard terms of probation.
I haven't even met with my probation officer yet.
Okay.
I meet with her on the 9th.
Mr. LaBush, just
I
listen
can't
to me.
even fucking talk or what? Fuck you. Fuck you, I'm done here, bitch. Later. Motherfucker.
Yeah. Saying that directly to a judge was probably one of the worst decisions he could have made. And at this point, the judge has officially run out of patience.
Record, Mr. LaBush has just walked out of the video advisement, also cursed. Is there still a deputy in? Well, I'll make a record here. He's not presently in front of us. The behavior that was just presented to the court, both cursing after he was previously given a warning not to curse, and then specifically basically telling the court to fuck itself, and calling the court a bitch because he was dissatisfied with the court's advisement is contemptuous behavior that does not require a prior warning. I think I'm going to do that. Who do we have covering advisements tomorrow?
It's me.
Well, no, I mean Judge Weiss.
Oh, Gardner, I believe. Sandra Gardner.
Okay.
Yes, Gardner.
Here's what I'm going to... This might make sense, Mr. Fowler, since I think I'm going to actually issue an order in this case and have him brought over tomorrow, close in time to the advisements. Oh, we have deputies back.
Sorry, Your Honor. Did you need something?
So I was just making a little bit of record. So I think this is how I'm inclined to handle this. I think he does need to be brought over for a contempt. My inclination is to set this over till tomorrow, and maybe set it after the other advisements. So, what would work for the jail?
Whenever after advisements tomorrow, Your Honor. I can make any time work.
So here's what I'm going to do. Mr. Fowler, if you want to make that, I'll make an order. I'm going to have this brought over tomorrow at 2:30 for an advisement on contempt, and that will conclude the hearing.
All right, so that wraps up that hearing. They scheduled him to come back the following day. But apparently he decided that avoiding the courtroom was a better plan than facing the consequences waiting for him there.
Can you give me an update on his availability?
Yes, Your Honor. We had him shackled. He walked out of the cell, decided he didn't want to go. He said, fuck this. You guys can drag me. I'm not going.
Okay.
I'll keep an eye out for his next court appearance. And I guess we'll find out whether he finally decides to behave like an adult or keeps throwing tantrums like an overgrown toddler. Now we move on to our next hearing. A road rage plea deal that immediately starts going off the rails the second the defendant decides to speak for himself.
Mr. Probick? Let's see. Mr. Probeck, 25 CR 1231. He's present. Good afternoon, Mr. Bibick.
Mr. Bibick, yes, thank you.
Thank
Good morning,
you.
Art. Good afternoon.
Yes, afternoon.
Good afternoon.
Yeah. All right, Mr. Probeck, a few questions for you. Make sure you understand the nature of this agreement. Okay.
Okay.
You signed the paperwork, as did your attorney, and then there was a form you had to fill out, which you did. Before you did all that, Mr. Bibick, did he advise you on everything and answer questions to your satisfaction?
Yes, he did.
And are you satisfied with his representation?
Yes, ma'am.
All right, you're pleading guilty, it looks like.
Yes.
Let's see. Okay. Okay. Pleading guilty to 2 counts, conspiracy to commit menacing, class 6 felony, and reckless driving. Is that correct?
Yeah.
All right. For the menacing, the class 6 felony, the penalties, the worst case scenario you could face are between 1 and 1.5 years in prison, followed by a year of parole. It could be a $100,000 maximum fine. Do you understand those penalties?
Yes.
All right. And then for the reckless driving, oh, good. I'm glad they. So it's apparently 10 days to 90 days in jail. And there could be a fine between 150 to $300. Do you understand the penalties there? Yes. Okay. Has anyone, Mr. Probeck, made any promises to you that are not contained in the paperwork here for you to do what you're doing?
No.
Are you entering into the agreement of your own free will?
Yes.
You take any medications or anything else that may affect your ability to understand what's going on right now?
No.
By pleading guilty, you are waiving your rights to go to trial. You sign paperwork indicating you understand those rights. Is that accurate?
Yes.
All right. And what about factual basis, Mr. Bibick?
Judge, we waive.
All right, waive. Let me ask you, did you go through the culpable mental state for you covered that with your client for the felony?
I did.
All right. Agreed. No. Gosh. Oh, it's with intent, right?
Yes, sir.
Okay. All right. Given the statements then by Mr. Probeck, Mr. Bibick, the court accepts the guilty pleas as knowing, intelligent, and voluntary. Stipulated. The terms are stipulated.
Yes, sir.
Okay. Well, happy to hear any comments regarding sentencing.
Thank you.
Yeah.
Shall I start?
Yeah.
Judge, this is a situation where Mr. Probeck was driving. The victim here and her husband were on their bicycles. They were approaching a roundabout, and there was a little disagreement about maybe who should be where as they went through the roundabout. And some words were exchanged between Mr. Probeck and the husband, Mr. Qualls. They were barking at each other, I guess we could say. And as Mr. Probeck exited the roundabout, he turned to his right to sort of continue that conversation. And unfortunately, his hands followed to the right. The car moved to the right, and it knocked Mrs. Qualls to the ground. From the discovery, it looked like she had maybe a fracture to her thumb. Mr. Probeck was insured at the time. Claims were made. He gave all the policy information. He did receive a letter from an attorney's office. I don't know if there's going to be further litigation on that. Perhaps there would be, but at least they've exchanged that information.
Policy paid the full amount. So.
He was, for some reason, charged with leaving the scene, but the video demonstrates that right after this happened, he pulled into the first available parking space, which was about 3 or 4 parking spaces up, and immediately returned to the scene and waited for the police to come. Mr. Probeck is generally a pleasant person, but in reviewing why he may have reacted as he did at the time, he's on certain medications, including duloxetine, and a known side effect of duloxetine withdrawal can be anger and irritability issues. I did some online research. I provided the district attorney with maybe 10 articles that are similar, that duloxetine withdrawal can cause anger issues. One of those articles was how duloxetine ruined my life, and people having to go through serious rehab to deal with those issues when trying to get off of this medication.
Or they have to wean off of it, something like that?
You have to wean off of it, and very, very slowly They talk about opening the capsule and removing maybe 3 of the beads to start with, and then working down from that.
Okay.
So it is a known issue. He stopped trying to wean off with his doctor. He's just maintaining his dosage, and he's managing it that way.
Okay.
Will he ever be off that? I don't know. But, you know, I'm leery personally about any of these drugs. Well, we certainly tout the benefits and downplay the side effects.
Sure.
But at any rate, he's addressing it in that fashion. He's very concerned about what happened. He's happy that she was not injured more seriously. But we think under the circumstances here and the charges, he was willing to enter into a felony plea, essentially. We think this is an appropriate plea, and we'd ask the court to accept it.
Got it. Okay. Thank you very much.
So that wraps up the defense attorney acknowledging his client's guilt and presenting the mitigating factors he believes should influence the sentence. Next, we'll hear from prosecutor as he reads the victim's statement, with the victim reportedly listening into the court's online portal.
Mr. DeShane?
Thank you, Your Honor. I have a statement from the victim. She's observing on WebEx, but prefers to have me read the...
So they don't want to make an oral statement?
Correct.
Okay, that's fine. Thank you.
I'll be reading it in the first person as she wrote it, just to be clear for the court.
Ah, got it.
Good afternoon, Your Honor. 30 seconds. That is all it took for Scott Probeck's anger and deliberate decision to change my life permanently. My husband and I were riding our bicycles home after a fun-filled day of listening to music and enjoying the evening when everything changed. I can still see Mr. Probeck's angry face as he yelled at us in the roundabout to get out of his way. After I exited the roundabout and entered the bike lane, Mr. Probeck turned his vehicle into the bike lane and struck me. I remember the moment of impact, being thrown onto the hood of his car and then hitting the pavement when he braked. That fear and violence are something I will carry with me for the rest of my life. The physical injuries from this incident are significant and ongoing. I suffered a fractured vertebra, a broken thumb, whiplash, and a compression injury to my arm. I also have permanent scarring on my calf from road rash. Healing is not meant returning to normal. It is meant adapting to pain, limitations, and the uncertainty of what long-term effects may remain. Beyond the physical damage, this incident shattered my sense of safety. I no longer ride with the same confidence or peace of mind. My husband and I both live with the emotional aftermath of that day. After reviewing the police footage and hearing witness statements, it is clear that Mr. Probeck acted out of anger and made a reckless decision that caused serious harm. This statement is intended to ensure that the court understands the full impact of those actions and the lasting consequences they've had on my life. I am deeply concerned about public safety, knowing that he will continue to drive despite intentionally using his vehicle as a weapon. I hope that the conditions of probation, anger management counseling, and bicycle safety education are enforced strictly to help prevent this from happening to someone else. This was not an accident. It was the result of rage behind the wheel, and it could have taken my life. I ask the court to consider the lasting physical and emotional and psychological harm this has caused and the ongoing risk to others who share the road. Warm regards, Tasha Qualls.
All right, babe. Thank you very much. I appreciate that. Anything else the microphone picks everything up, Mr. Probeck. So everything you just said, I'm sure Ms. Qualls heard it.
One thing I would add, Your Honor, aside from asking the court to accept the stipulated plea of the parties, is as part of that, I do have a letter from Ms. Qualls' attorney assuring us that the insurance has taken care of the restitution.
Then they, okay. That's okay. So what do you want me, in other words, no restitution? Is that what you're saying?
Correct. It's all been handled civilly.
Okay, got it. All right, Mr. Probeck, anything you wish to say before I impose a sentence?
Now, this is the moment where everything starts falling apart for the defendant. This is his chance to show accountability, express remorse, and ask the court for leniency, or he can choose the alternate route and spend his time blaming the victims while insisting none of it was really his fault. Take a guess which option he goes with.
Yes, sir. Obviously, the only thing anyone wants to hear from me is to apologize to Ms. Qualls and her husband. Obviously, I feel horrible for the pain and injury I caused them. It was a nightmare for me, too. It really was. I call it Nightmare in Remington. It felt like the events that happened. It was almost gothic. It almost felt like something out of, a conspiracy theory or something. I was surprised to find this gentleman in the roundabout yelling at me and waving his hands. I didn't know what was going on. I was kind of in a bad place mentally. I was sad. I realized later I was withdrawing from this duloxetine, which was given to me to withdraw pain from diabetes. I have diabetic retinopathy, neuropathy. Didn't do that, but it's also it's antidepressant. So when you get off of it, it can cause you to feel overly sad, which I was feeling. It wasn't so much rage as an inability to control my impulses. What I did when I passed Mr. Qualls, he had the dirtiest look on his face, ugly look on his face, and I felt myself snap, like something came loose in me. And I entered another gear, and I saw myself with my hands on the wheel just go like that, just a little bit. And I was unable to resist that impulse because I was withdrawing from duloxetine. So I did that. I could have kept going, and Ms. Qualls was directing me to keep going, waving at me again. And instead of doing that, I did the opposite. And it was meant to be a quick little thing. I was just trying to scare her a little bit, just trying to be a little FU type thing. And it turned into the slow slide where it was just horrific. And to try to explain that was really hard at the time, because did you do it on purpose? Yeah, kind of, but I was out of my mind at the time. So, that's what it is. And I'm relieved that I didn't cause more damage to anyone. And I obviously intend to complete with this agreement and to prove myself being a good citizen in our community. And I hope that Mr. and Mrs. Qualls will accept my apology. And I wish the best for them. I tried at the time and obviously didn't go over very well. I mean, he just tried to punch me and got in my face and was hitting me. I could understand.
You're not helping yourself right now.
Okay.
So why don't you stop? Since you're
No
not-
sympathy from you, I guess, Your Honor.
I did ask you to stop. You're not the victim here.
Oh, I was in this too. My kids were on that beach too.
Mr. Probeck,
Stop.
You should generally take the hint when your own lawyer is signaling for you to stop talking. But for whatever reason, he decided it was absolutely necessary to squeeze out one final sentence, despite his attorney clearly advising him not to.
Deputy, please.
F you to
Hello.
all of you.
Oh,
Excuse me, sir.
all right. I'm holding you in direct contempt for having said that. We will deal with sentencing on the contempt right now after I sentence you in this case. You have now exceeded all reasonable limits and bounds of decency in this proceeding. So, I do accept the agreement in the 1231 case. So, let's see. The sentence is a 2-year supervised probation on both counts. They will run concurrent to one another. Clearly, an anger management evaluation and follow through with recommendations for treatment is in order. A bicycle safety course must be taken. 50 hours of useful public service, and remain law-abiding. Counts 2 and 3 are dismissed. Now we're dealing with the contempt. Any statements in mitigation?
I am sorry, Your Honor. I mean, I'm very emotional here, and it just felt like that your reaction to that was completely opposite of what I was hoping for. I was hoping to help myself in this case, for you to hear me and who I am. I'm not a psycho here. I'm not the kind of person that goes out and tries to hunt people down and mow them down. Some people thought that.
Why would you say F you? I don't need to have an order in effect telling you that that's not an appropriate thing to say.
I apologize. It was just an impulse thing. Obviously, I'm not always best at controlling my impulses, even when I'm not withdrawing on a very powerful drug. Sorry. I don't have anything against you, and I actually like you from the interactions we've had. So,
Counsel,
no disrespect.
anything on your client's behalf? I know you tried to stop him, but he didn't.
Judge, he's not completely with me either.
Yep.
I can just apologize on his behalf, Judge. I'm sure what else I can tell you.
All right. Direct contempt may be punished summarily, and the court need only make simple factual findings to support a finding of contempt. This is in Remarriage of Johnson, 939 Pacific 2nd, 479 to 481, 1997 decision of the Colorado Court of Appeals. Summary contempt is a power which is necessary to ensure and preserve decorum in the courtroom. Such power is not designed to protect a judge's own dignity, but rather to protect the rights of litigants and the public and the victims in this particular matter. It should be invoked only when the judicial process has been seriously affronted or disrupted. People v. Holmes, 967, Pacific 2nd, 192 and 194, 1998 decision of the Colorado Court of Appeals. In case you're wondering, I have held people in direct contempt for saying the very same thing that you said. So the court finds that the defendant's conduct of saying F you after the court asked him to stop talking is so extreme that no warning was necessary. And of course, despite that, I gave him a couple warnings, certainly to be quiet, and he didn't follow those orders. The court simply will not let that stand. So because of that act, and that frankly is reprehensible, and then the other statements that he made, I'm going to sentence you to 1 day in jail. Straight jail.
Insult to injury.
1 day in jail. He'll be remanded right now.
Straight. Right.
Sorry.
Well, there you have it. Another courtroom disaster where someone managed to get themselves arrested by behaving like an idiot on the official record. Hopefully, a little time in jail teaches him that acting reckless in court can come with very real consequences. Alright everyone, that's the end of the video. That's probably the last time we'll see the final defendant in court. But the first two clowns almost certainly still have more chaos ahead of them. If you enjoyed the video, leave a like. If you didn't, leave a dislike. Either way, don't forget to drop a comment below and subscribe with notifications turned on so you don't miss any future content.